Blewett. Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything.
When the judge lays down the Miranda rights and throws in talk of probable cause, he isn't just reciting words, he's drawing the battle lines. Probable cause isn't proof of guilt. It's the bare minimum spark the system needs to keep the case alive and drag it forward at this stage. Every word out of your mouth can be turned into a weapon against you. That's why silence isn't just smart. It's a shield, the strongest move you've got when the system is already geared up to crush you.
Cannon will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault and progress call. The officer met with complaining witness one, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The complaining witness,
This is where the case twists into dangerous territory, legally and emotionally. The polyamorous angle may fuel drama and distraction, but the court isn't here to untangle feelings. It's zeroing in on one thing: the assault. A single proven injury, a cracked tooth, a bruise, can hit like a hammer in court. Under assault statutes, that evidence alone is enough to lock the charges in place and keep the defendant trapped in the system's grip.
the first complaining witness stated the defendant had struck him in the face while the defendant had a phone causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness one was trying to calm down the situation, the defendant struck complaining witness one in the face, and in the process of breaking the fight, the second complaining witness was struck in the shoulder, causing pain.
When the judge throws down a protective order and warns about revoking bond, it's not courtroom theater, it's a direct threat. Break that order, even by mistake, and the hammer falls fast. Straight to jail, stacked with fresh charges. Judges don't hand out these terms for show. They're drawing a line in the sand to keep control and enforce safety before trial. From here on out, compliance isn't optional, it's survival.
But we only have the assault on the gentleman, correct?
The assault's only on the, I'm sorry.
The gentleman.
I believe so,
You
yeah.
only got one count.
Yes, sir.
Okay. Ms. Blewett, I'm going to find if there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, man. Do you have the ability to hire a lawyer?
Got a phone, a lawyer, court opponent.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda's going to give you an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Can you file me to contact me?